Hello again. A new witness of the Senzo Meyiwa murder case has applied for her testimony not to be broadcast live. The witness says she believes this would endanger her life as she is a public figure and would have a negative impact on her career as a performer. Meanwhile, all the defense lawyers have rejected the application. Zola Sholwana is standing by to tell us why. She's at the High Court sitting in Pretoria. So essentially, the state only got this notification that this new witness, whose name is yet to be made public, is not ready for this, well, for her testimony to be broadcast live. Zola.
Yes, you're right, Dudu. We have been waiting inside the court, and we heard that the witness does not want she doesn't want to be broadcasted, actually, and, she mentioned the reasons, one of them being the fact that she's obviously, a public figure, and that could possibly endanger her life, and she also spoke about how people can take what she said in court and actually turn it to something else on social media, and, that will naturally be brought to her attention. Also, she said that, if she's broadcasted live, then she'll be uncomfortable, and that could possibly hinder her continuing with this case. Let's actually have a listen at what the state prosecutor said.
The witness is a well-known personality. She has to perform in public from time to time. And if these proceedings, my lord, are carried live, there's a possibility that the public might form perception regarding her evidence. And when she then performs publicly, her life might then be endangered. So the first reason, my lord, is for personal safety. The second ground, my lord, is that if the proceedings are carried live, that will put pressure on her. It will make her uncomfortable. She's under no circumstances, my lord, prepared to give evidence if the proceedings are carried live.
So what she basically said is that journalists can sit in court, and notify, the people, the public rather, but make sure that they don't broadcast what is happening. And in that way, people will still be informed. That's what was said. And Dudu, this is someone that, is said, according to the court, has been featured in a Netflix documentary and also participated in multiple interviews regarding this particular case. So also, concerns were also raised about, the accused. One of the accused actually said they had hoped that their family members get to watch today's proceedings. The family members are in KwaZulu-Natal, and unfortunately, due to financial constraints, they cannot make it to the court. And, they also mentioned that, they spoke about the family of the deceased, Senzo Meyiwa's mother, who would have loved, to watch today's court proceedings to find out what will be coming from the states, from the witness that we'll be seeing after 2 o'clock today. Let's have a listen at what the defense lawyer said.
We're hearing from the submission from the state that on her own she says she's a public figure. She's out there. She's out there. Everybody knows her. So I'm very surprised, my lord, to hear that her testimony here at court will make her feel uncomfortable. She will be criticized. It will be interpreted in different ways. My colleague has already alluded to that, my lord. So it's my submission, my lord, that in as much as there are also two witnesses who were in that very same house where she was, and that's evidence before court, that makes no difference. She cannot be elevated to some position that is more, that's not similar to the other witnesses who were actually at court.
this is an embarrassment to the South African law proceedings that at this stage during trial we are still dealing with this kind of an application. An issue, my Lord, which ought to have been discussed at a pre-trial conference stage before we started with this trial.
Zola Sholwana, thank you very much for that detail. We'll touch base with you a little bit later on. Listening in on that is Elton Hart. He's a senior partner at Hart and Associates and attorney at the University of Johannesburg's Law Clinic. He helps us to make sense of what the judge will be seized with. And Elton, this, as we appreciate that we're still waiting for a legal representative on behalf of the media. We understand they will then be there at 2 p.m. But let's pick up on what Advocate Mshololo on behalf of accused number 5 had to say. Very vocal and strong against the timing of the state having brought this up now. Also the state making it known that they only got this concern from this particular witness last night. Again, a question was asked, why then did the state not last night make it known to the defense rather that this will be an issue today? What do you perceive, or how heavily will that weigh on the judge when he has to make a decision on what to do, whether this witness's testimony must be broadcast, at least the audio visual, or not?
No, for me it's simple. This witness cannot be elevated to something special. She must come and testify. If she doesn't want to come and testify, they can easily subpoena her to come and testify. So there is no way of her actually holding the court hostage to say, if I'm not granted this permission not to be televised and stuff, I'm not going to testify. You just subpoena, she must come. If she doesn't come, they issue a warrant of arrest for her to be brought before court. And even if she comes and she recants whatever she said in statements, then there's a procedure in the Criminal Procedure Act that says you can declare then a hostile witness, that she's not open, frank and honest with her evidence, and then that will not be good for the state. And I think Advocate Baloyi, as a legal representative and a member of court, he ought to have sat down with this witness and advised her that she cannot do this. He, as a legal practitioner and an officer of court, has a legal duty to tell her what's the implications of her decisions not to come and testify. Not to just come and stand there and say, yes, court. He should have advised her that this is bad in law, what you are trying to do. And I think the witness, she must just come, because for her, she doesn't have an option here. It's simple. And the judge needs to weigh up now here her personal interest compared to the public interest, because there's a big public interest in this case. It's 10 years nearly in the making. So for me, the judge, I can't see why he would now overrule a previous order that was made. And the mere fact that Advocate Baloyi is coming and saying he received it last night, he has the contact details of the other attorneys. Why not contact them immediately to say, listen, yeah, this is the problem I'm facing now. When I had my consultation with this witness, she did not come up and tell us, listen, yeah, I will have a problem with being televised. And the mere fact that she says her personal safety, she goes on social media and publishes about this case. So for me, that argument of her personal safety will be compromised. We're not saying that they're not going to ask her, where do you stay, where do you currently stay, where do you work. That's not the question. They will ask her as to what happened on that night. So that's a flimsy excuse that she's bringing up, or that the state is advancing on her behalf.
What to understand of the judge interjecting on that particular point when Advocate Mshololo brought it up, and he was then saying, and I think he even brought it up before with another defense advocate, saying, well, even though she participated in the Netflix documentary and she has been public, what if she now has realized the error of her ways? Not his exact words, but in just paraphrasing his understanding of the objection, that perhaps maybe she learned her lesson, and maybe that's why she does not want these proceedings to be broadcast live. What to make of that behavior by the judge? Is that normal?
No, the judge can canvass it with the defense attorneys, but I think in terms of Section 197 of the Criminal Procedure Act, if you testify or give evidence about certain things, you then lose that shield. Say, for instance, you raise certain personal issues about yourself. You lose that shield that the Act gives you. So she cannot now come and say, okay, I've testified or I've published about myself and about this case in the past. Now I want the court to protect me. Why do you want to now protect yourself? You should have obtained legal advice before starting to publish. Even so, similar to a person committing a murder to say, okay, I've committed a murder, I'm sorry for my actions, and now I want you guys to excuse me. You cannot work like that. She cannot pick and choose when the law should be applying to her. She should have thought about that, and if she was not sure, get yourself a lawyer that's fully equipped with what these publications and the media law says, and then act upon that, not go haywire. And now you see that because there's pressure, because she's saying also she's afraid of the pressure. The judge's pressure, the lawyers represent as pressure. There's pressure in this case because somebody is going to jail. So those accused persons also has pressure on them for being accused of something that they haven't done. So that is also some pressure. So
Sure.
she must deal with the pressure. Life is about pressure. She cannot pick and choose when pressure should come and when it should not come.
Elton, Advocate Mnisi, on behalf of accused number 3, suggesting rather that the judge should take what has been presented by the defense from the bar instead of them having to file heads of argument in the interest of time, arguing that, well, it might take a few days and that may delay proceedings even further. Given that Judge Chifiwa Maumela is also facing rather possible impeachment, he then replied and says, well, this is a precedent-setting case, and it should be avoided to be seen that things are being done hastily and not laboriously, and we should not be seen to have ignored processes because it is rather the shortest route. What did you understand of that because of that allegation that the rulings take time, or his rulings amongst others that have been accused, or another that has been accused, a judge that is having taken time?
No, for me, taking it from the bar or getting written heads of argument, for me, it's the same thing because the record in court is transcribed every day. So if you want to say, okay, I want to see pieces of paper, how you argued, I just print the transcript of the day, and then I go through the transcripts and say, okay, this is what defense lawyer for accused number 1, 2, 3, 4, 5 has said. And then this is what the state has advanced. And there you have it on a transcript. So it's in written format. So you can't say the written format is just most probably that the judge wants them to also refer to case law. But you can even refer to case law from the bar, as what Advocate Beloy has done. This would just throw a spanner in the works and delay the matter, because now you have to listen to substantive applications, heads of argument being presented in court, which is more extensive, because now if you write it down, you'll go over the time limit that you would normally do from the bar if you have to do it without a written piece of paper. So it will just delay proceedings, and then it goes again to justice delayed, justice denied. And for me, this is already way too long, and as rightfully as Advocate Mshololo said, these things were supposed to be canvassed at pre-trial already, that you foresee possibilities. You cannot tell me with this type of trial you don't foresee a witness coming up to you later and say, I don't want to be televised and stuff like that. You can foresee that, and you should have set that in motion already. So for me, the judge also to say that heads of argument, I understand where he comes from, but you can easily overcome that because we know there's time pressures in this case.
Thank you very much to Elton Hart, Senior Partner at Hart & Associates and an attorney at the University of Johannesburg's Law Clinic.